jurors in the Derek Chauvin case are now slowly speaking out. We learned very recently that the alternate juror, a woman by the name of Lisa Christensen, is out there. She's actually talking to the media, and she in fact shared her notes with us. She took notes on lined paper. We've got some scanned copies of that we're going to go through. But she was an alternate juror. So she was a part of the trial. She sat in there throughout the entirety of the case. But then at the very end, right before the jurors went into the deliberation rooms, judge said, sorry, you're the alternate. So she got booted out. Nevertheless, she was still there for the trial, and so we can see how the trial impacted her. But we now heard from another juror today, a guy by the name of Brandon Mitchell. He was juror number 52, 31-year-old basketball player out of the North Community High School in Minneapolis. He was a part of the deliberation. So not only did he sit in the entire trial, but he was back there in the deliberation room with the other jurors, sort of hashing it out. And so he was on ABC News explaining a little bit about what happened in the deliberation room. And we want to go through this because a lot of people are sort of scratching their heads about this thing. You know, it was a very short deliberation. It was about 8 hours, and it happened very quickly. And there was weeks of testimony. A lot of medical expert witnesses were there presenting in court. And so many people were saying, hey, why did it take them 8 hours to come to a conviction? I mean, there's a lot more data they could have combed through. Why didn't they do any of that? It seems like it was kind of open and shut. They all walked in, came to an agreement, walked back out, and there was Chauvin guilty on all counts, even though people like yours truly, other individuals we've heard from who've been on the show, in fact, we had Viva Fry, we've got Robert Barnes, we've got the Law of Self, Abranca. We have many other people who are defense lawyers by trade and training and who have a lot of experience with these types of cases, saying things like, hey, there was plenty of reasonable doubt here. It's very difficult for us to fathom a case where there could be where it's possible to have more reasonable doubt, given the fact that there were so many, I would say, external causes or superseding intervening causes that we can connect to George Floyd's death. And I'm talking specifically about fentanyl, meth use, 2019 prior, with last-minute ingestion theory in that case. We had blood pressure, 216 over 165. I mean, the list goes on and on. I've beaten that up to the end of the earth on this channel. I don't need to go through that again. But the question has been, did Derek Chauvin get a fair trial? Ultimately is what a lot of people are asking. And they're saying, no, how could he have? Because it happened in Minneapolis. The city council settled for $27 million right in the middle of voir dire, as the jury was on the verge of going into the deliberation room before the trial had even closed, before closing arguments had been delivered. Maxine Waters comes out, flies into the city, starts throwing around bombs in the air like if there's not a conviction on all counts, there's going to be, more blood in the streets, essentially, is where she was going with that statement. So, judge didn't change venue, judge didn't continue the trial, judge didn't re-voir dire anybody. And so many people are going, hey, this is not a fair trial, right? You may be happy with the outcome. Nobody loves Derek Chauvin, right? I started this show really to sort of hold the cops accountable, and prosecutors and judges and police officers and everybody involved in the justice system. And so I've got a very strong vested interest. I'm very much inclined to find fault with law enforcement. That's the basis of this channel, but not at the expense of the reasonable doubt standard. That supersedes everything. I don't care if it's a cop, it's a politician. I don't care if it's Joe Biden or Kamala Harris, who I have no love for either one of those people. But if they get charged with a crime, they still deserve the presumption of innocence, and they are entitled to the presumption of that in conjunction with the beyond a reasonable doubt standard that exists in our society. So everybody deserves that, regardless of what type of crime you've committed. It's irrelevant. It's the basic standard. It's where we all start. So the question has always been, in my mind, did Derek Chauvin get that? We already know how, I would say, prolific the video was all over the country. And we saw that the entire media apparatus, all the politicians, everybody was sort of in alignment to convict Derek Chauvin. Even I was. Go back and watch my video back in May of 2020. I was very angry at him and the whole situation. But that's not enough. You still have to prove that beyond a reasonable doubt in the court of law. So again, we go back to the question. Did he get a fair shot? Did he get a fair trial? Was this a fair shake? And we have to go through, and now we have some more evidence that we can compare and contrast this to. We have a juror now, a guy by the name of Brandon Mitchell, who is this gentleman right here. He says, the article comes over from ABC News, said that Brandon, who was juror 52, was in the trial of the officer Derek Chauvin for the murder of George Floyd. Said being in a courtroom for the high-profile case was like, quote, watching somebody die on a daily basis, which I I totally would agree with that assessment, right? Because the prosecution showed the video every opportunity that they possibly could. They showed it to every single witness. Oh, what's happening there? Oh, the knee on the neck. Oh, tell me about that. Oh, well, what's your opinion on the knee on the neck? How about your opinion, doctor? Well, back that up again. Play that again in super slow motion. I want to make sure that we can see every minuscule fiber that's moving in super slow multiple different angles, because it was so damning, right? And I'm being facetious here and exaggerative, but it's the point here. They took something that was highly emotional and they made sure to rub the jurors' faces in it every opportunity they could. Good strategy. They should have done that. They did, and they did it effectively. And so this juror comes back out. Yeah, it's like watching somebody die every single stinking day. So you can imagine the type of pressure and what that does to a person's disposition. Very effective trial work from the prosecution. This was always going to be a burden that the defense was going to have to overcome, just given the gravity of what we saw. The video was so stinking bad. How do you overcome that? Mitchell, 31-year-old basketball coach at North Community High School in Minneapolis, said he and the other 11 jurors didn't watch the news during the trial or deliberation, so they weren't aware of the racial climate or protests going on. Well, we're going to listen to him. We'll see if that's accurate or not. I mean, this was going on before the trial, so why would it stop? We were really just locked in on the case, Mitchell told ABC News' Robin Roberts in his first television interview, which aired this morning on Good Morning America. I mean, those things are just so secondary because you're literally throughout the trial watching somebody die on a daily basis. So that stress alone is enough to take your mind away from whatever's going on outside the four walls of the courtroom. So, right, obviously, they're supposed to be removed from the news, but as we are going to hear from another juror, she was traveling back and forth between some of these cities that had a lot of unrest. So if there's protests surrounding the court building and the jurors have to come, from their house to the court building and back on a regular basis, they're going to see this stuff, whether they're watching the news or not. Judge didn't change the venue. It's all happening right out of Minneapolis. So how could you not know what was going on outside of the four walls of the courtroom? Anybody believe that? No, of course not. Mitchell said the deliberations were relatively, quote, straightforward, but that there were a few hiccups with terminology and understanding exactly what the instructions were. Said there wasn't too much banter back and forth. I think the one juror that was kind of, I wouldn't say slowing us down, but was being delicate with the process more so, was just kind of hung up on a few words within the instructions and just wanted to make sure they got it right. Mitchell said he wanted to publicly extend condolences to Floyd's family and then let them know that his name is going to live on. His legacy is now cemented in history. It's now become much bigger than him as an individual. It will hopefully create some change within society, says this juror. So this is Brandon Mitchell, who is the 31-year-old basketball coach. And when we watch these clips from him, right, the question that I want you to ask yourself, it's not a fair question, but it is something that I think is important to just exercise. Okay, what we're asking of a juror. And the reason I say it's not fair is because we're human beings. It's not possible to sort of disassociate yourself from what you experience in the world. And many people say that they can. Oh, I'm not mad about that, or that thing doesn't bother me. Yeah, right. We all know it does. So we can sort of live according to this nice little white lie that we can all disassociate ourselves and we can all be fair and impartial. And we all know that's not really true. It's kind of this legal fiction that exists. So all of these people came in front of the jury panel, in front of Judge Cahill, Eric Nelson, Steve Schlucher, and all of the other prosecutors, and they asked them a bunch of questions. And the final conclusion, what they wanted to draw out of them, is whether or not they could set aside all their prior conceptions about this case and be fair and impartial, right? And we heard that. We covered it on this channel. We spent a lot of time going through every single day, voir dire for every juror. We had clips. We listened to the audio. We were reading the transcripts and on and on and on. So it's very important. This went on for a long period of time. Can you be fair? Can you be impartial? Did you see the video? Yes or no? If you did, can you set that aside? We want you to go in as a blank slate, tabula rasa, nothing on there, as best as we can. Now, we know that that's not really even possible. Okay, and we know you're going to try your best. You're going to go in with an open mind. But we all know that a lot of the time in these cases, the decision is already made up in a juror's mind before you even step foot into the courtroom, right? And it's a tall order to ask a defense attorney to try to reverse that course on a regular, standard, generic vanilla case, not a national case involving one of the most in-your-face, gruesome, incidents where an officer is killing somebody else. According to the courts, that he's convicted. So that's kind of a fact now. The jury said so. So it's very traumatic and it's very powerful. And so now we're asking a juror to sort of unring that bell, which we all know is virtually impossible. So what do we get now? And how do we cipher through this as a society? Because this is happening on and on again. We're going to go through a number of other stories in the third segment of this show today, where we're analyzing more shootings, right? So this is not going away. So now we have to analyze the role of jurors in this new era. This is a new thing that's happening right now, because typically we've had high profile, high stakes cases before in this country, right? We've had OJ, we've had Zimmerman, we've had them all. We've gone through this. That's not new. There's always going to be high profile criminal cases. That's not what I'm talking about. What I am talking about is sort of this unification of the media and the power structure to be involved in the court of public opinion in the prosecution of certain particular criminal defendants. We're seeing it right now with the Capitol Hill protesters, the rioters. They're all getting a second tier of justice, right? You may not agree with that, but if we've gone through the analysis here, if you can give me a good explanation as to why the Justice Department is giving sweetheart deals to all the Antifa protesters from a year ago, diversion deals and deals where their criminal charges will ultimately be evaporated as soon as they complete community service, why are they getting those deals while some of the January 6 people are still in custody, not being granted bond? Both are the same types of charges: interference with government functions. Okay, the Antifa people were throwing Molotov cocktails at court buildings, so don't tell me that's not interference with the government. Same set of circumstances, totally different scales of justice. We're seeing this across the board. Now we're seeing the media weigh in, and politicians and everybody weigh in on very local criminal cases like Derek Chauvin. Kamala Harris weighed in, Joe Biden weighed in, Maxine Waters from California weighed in. People from all over the country are throwing their 2 cents in. And it's not just about expressing an opinion. It's about saying things that are likely and foreseeable to impact the result. It's likely to impact the public opinion as to any one particular issue. And they're actually going there and generating fervor in order to achieve that particular outcome. In this case, we're talking about Maxine Waters and other people. So now you sort of have to think about this in 2 different fronts, not only in the court of law, but also in the court of public opinion. And there's something interesting happening here where now, as we're going to hear from Brandon Mitchell, I want you to listen to this and I want you to think about this. Is this a person who, look, and I know this is not fair, right? Because how can you ask somebody in a situation like this to be fair and impartial? But now we're looking at this after the fact. This guy he sat through basically 4-week trial, came out the other end, and now he's explaining to us his deliberative process. What happened on the inside? What happened when we were in there in court deliberating with the other jurors? And as we go through, I think we have 3 clips. When we get to the last clip, got to be asking ourselves, is this somebody that we believe went into the courtroom trying to be fair and impartial? Let's just say that, right? It's a difficult standard to ask if they were or if they cared to be or any of those things. But ask yourself, right? Ask yourself this. Does this person sound like a fair and impartial juror, or somebody that tried to be fair and impartial? Or does this sound like somebody that went in with an agenda and that has a political motivation throughout the entirety of the case? Because yes, this is after the fact. This is somebody who came out, and you can make the argument and say, well, his opinion changed based on the evidence that he saw. So you could say theoretically that, well, yes, he was fair and impartial the day of opening arguments. Before the trial started, yeah, he was fair and impartial. But all of that changed when the evidence was presented. Okay, so we'll grant you that. So then we're going to listen to his motivation as to what the consequence is of this. Why should people be on jury panels? He gives us some insight into why he thinks this was such an important thing for him to be a part of. And he's explaining his disposition prior to making it onto the panel. Okay, it's doesn't make any sense right now, but it will in a minute. So let's go into some clips. This is a quick overview. This is Brandon Mitchell speaking with Miss Roberts, who's on ABC News. First juror to speak out. The first juror who is a part of the deliberative process is now on ABC News this morning. Let's check it out.
First, I want to start off by sending my condolences to the Floyd family. I haven't got a chance to do that publicly, so I want to do that first and foremost. But no, the deliberation room, it was pretty much, for the most part, it was straightforward. There were a few hiccups with, terminology and understanding exactly what the instructions were for each case. But like I said, for the most part, we got in, we got out. There wasn't too much banter back and forth.
Was there one juror, though, on one of the lesser charges that was a holdout for a while?
Yeah, so I mean, we probably deliberated for 4 hours, and of that 4 hours, it was. I guess we were going over more so the terminology that was being used and making sure that we understood exactly what was being asked. I think the one juror that was kind of, I wouldn't say slowing us down, but was being delicate with the process more so. Was just kind of hung up on a few words within the instructions, and just wanted to make sure that they got it right.
And so how were you able, and that's how you were able to convince this particular juror? Clarification on the wording?
So we just kind of went around the room. We literally broke down the sentences and broke down the words and what the meanings were. It just described it several different ways from different perspectives until we came to a common conclusion.
Okay, yeah, so it sounds like very, very generic deliberation, right? There's somebody out there who goes, I really don't understand these words. They got delivered a whole set of jury instructions as we've gone through on this channel. We went through them and sort of reviewed them. This is what the jury does. They say causation. They say, what was depraved mind or depraved heart. And they go through and they just sort of define the terms that the judge tells them apply to the facts of this case. And so nothing really interesting there. Very, 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 generic. You've got somebody who says, I will kind of really don't understand this. The rest of the crew is going to make sure that they nudge them into their line of thinking. And so that's it, right? Pretty simple. And as we know, it was simple. It was very quick. They did not spend much time on this. In the next clip, though, we're going to hear about the sort of the impact of the video. So remember earlier in this segment, I was explaining that they beat the hell out of this video. They were just rubbing the jurors' faces in it all day, every day, at every opportunity. They had multiple expert witnesses talk about it. We had multiple diagrams. We had arrows. We had charts. We had the whole thing. I think we had 3D renderings of it from Dr. Tobin or something very similar to that. And so Ms. Roberts asks him, says, hey, what was the most important piece in this case? What was something that was dispositive? What made you come to the conclusion that you did? Was there anything that you can point to? And he does. It's the video. And as we all know, it's Dr. Tobin, right? Dr. Tobin really, in my opinion, was a person who convicted Derek Chauvin due to the power of his testimony. It was very effective. But let's listen in and see what this juror had to say about it.
The video is it's a historic video, unfortunately. And then seeing the multiple angles of it from the body cams, from the other cell phones, it was probably the most important piece of evidence. Was
there any testimony? Was there one piece of testimony for you that made a difference?
So for me, I'll say two. For sure, Donald Williams, just how he spoke about everything. And Dr. Tobin, I think once Dr. Tobin got on the stand and the way he spoke and the details that he gave and the way he gave the details, I thought that really solidified the prosecution's case.
Yeah, it was. Dr. Tobin was very powerful. And so, again, it was the video and Dr. Tobin. Both, I think, of course, were very, very, very strong pieces of evidence and testimony that came into court that probably did it. And it was not easy for the defense to overcome both of those burdens. Now, the last bit, the part where I think the facade sort of cracks a little bit on this interview, and listen, right, this is a layperson. This is a 31-year-old basketball coach. So I'm trying not to belittle this guy or to, come down on him in any way or offer a judgment as to his position on this even. Really, I mean, it's his position. And it's important, I think, that we treat treat everybody in this case with some empathy. This is a man who is trying to do the right thing for himself, for his family, for his community, for his demographic, for his race, whatever he thinks he's doing. I think he's doing it for the right reason, right? I think he's out there trying to make the world a better place. He feels like the society is a certain way, and he needs to do something to be a part of the solution. I'm not so sure that I agree with him based on this next statement that he makes, but we have to understand, right? There are multiple different individuals and different interests involved in all of these issues, and it's important that we accept and listen to them rather than just throwing them out at face value, because this is a reality. This is going to be happening. Now, I want you to listen to what he says. We have Roberts specifically saying, what is the importance of black men showing up for jury duty? And says black men, okay, specifically about this. And here is his answer. Let's listen in.
Your experience, you believe, has shown the importance of black men to show up for jury duty. Why do you believe that?
Yeah, so I mean, in order for change to happen, we got to get into those type of avenues, get into those rooms. We got to show up for jury duty. We have to vote. Those are things that are important to the society as a whole. And if we want to be viewed differently in society and start to see different results, we have to start to do those things. We cannot avoid them. We can't put them on the back burner. We have to put them in the forefront. And jury duty is definitely one of those things, especially with, you know, the insane number of black men being incarcerated. So yeah, so we definitely have to get on those panels and stuff like that.
So we definitely have to get on those panels and stuff like that. In other words, we got to be aggressive. We got to sort of elbow our way onto the jury panels as a form of political involvement. There's way too many people, way too many black people, he says, incarcerated in our federal prisons. I agree with him. I think there's way too many people of all stripes and colors in our federal prisons. But he's saying specifically that they're going to get on. Why is it so important that black men get on jurors? We got to get out there so that we can express our political opinion. I'm okay with people expressing their political opinion. I want everybody in this country to feel like they're a part of the process and that they have their voice and they're being heard. But I'll tell you this, the jury panel is not the right place to do that. This is not what this forum is for. If you've got a political gripe, you go do that with your legislature. You go do that with your elected representatives. You don't do that on the jury panel. It's not your position in here. You may have a lot of problems with the justice system, and I do, believe me. But the way that you get a justice out of the justice reform, the way you get systemic change in our society is not by going and convicting one particular person, somebody by the name of Derek Chauvin, right? Because that is not about that. Now, you may want to make it about that. You may want to say, well, symbolically, Derek Chauvin represents, it's symbolic of a deep-seated problem that exists throughout our justice system. And I would even agree with you on that, right? That a lot of these cases have some tentacles and some remnants that extend far beyond them. But that's not the point. The point is those get addressed in other venues and other avenues, not in the court of law. Derek Chauvin or any defendant is presumed innocent until proven otherwise. This is a big problem. Okay, basically what he's advocating is the same thing that happened back in the 50s and 60s when, a black defendant would be on the other side of the table and you'd have a bunch of white jurors who say, I just don't like the black guy because he happens to be black, and they're going to use their position on a jury panel for their political motives, for their political ends. So if we're just going to flip that script and say, okay, well, we're just going to put black people on a jury to convict white people because of I don't know, white privilege or racial injustice or equity or whatever it is. The white people did it for 50s, 60s, 70s, 80s. Arguably, maybe some of them think they're still doing it today. So we're just going to turn the tables now. Now black people are going to do it to white people as though this is some sort of equitable balance. Like, it's insanity. So it's not okay. Principally, it's a bad thing. It's bad when the white people did it. It's going to be bad when this guy is sort of encouraging this, that, African Americans make it onto jury panels in order to express their political displeasure at our justice system. It's one venue. It's one way to do it. I disagree with it. I think it sort of undermines the premise of the entire judicial system. If we're going to politicize every single criminal case, it's going to fall apart quickly. I mean, the courts are sort of the last bastion of, or supposed to be, overly politicized criminal prosecutions. And if it's going to be like this, if basically this guy's advocating for other people to make it onto a jury panel and then exercise their political disposition, that's not the role. You're supposed to be on the jury panel with the presumption of innocence, with a clean slate as best you can. We know it's impossible, but as best you can to give that person a fair shake. And if the evidence presented in front of you convinces you beyond a reasonable doubt that that person is guilty, that's when you convict. That's when you vote for that conviction. It's not because it's a white police officer. and you've got a problem with the justice system, as do I, as I do with many other things in this country, but I'm not going to take it out on the back of any single defendant. And, for some reason, this is looking like this might be a valid option. Like, this is something that we're going to see more of. If the courts are not going to give this movement the outcome that they want, then they're going to nudge the courts. They're going to play the game. They're going to use their own rules against them. Sure, we'll get on the panel. We'll convict every single cop that comes through here, whether it's justified or not, because it's a political statement. It's not a statement about justice. It's a scary problem. And we saw on ABC News, kind of just let that one go. Okay, well, yeah, if you want to get on there and just make a statement on the jury panel, so be it for the defendant. Good luck to that person. Now we have another juror who came out. This is the alternate juror. Her name is Lisa Christensen. So she met with Lou Raguse over from CARE 11. She was the alternate juror, found Derek Chauvin guilty of Floyd's murder. She lives in a city where a white officer shot and killed 20-year-old black man during a traffic stop this month. That was Dante Wright. Dante. He said that if she had been part of the deliberations, she also would have found Chauvin guilty. Christensen had no idea that she was one of the two alternates until the judge dismissed her right before the 12 jurors were sequestered. So she was on till the very last minute. Not going to spend a ton of time with her, but I just wanted to show you a couple clips. And then she did give the news agency her notes. So we actually read through some of them. Pretty interesting. So here she is speaking to CARE 11.
Every time
K-A-R-E.
she locked eyes with Derek Chauvin during his murder trial, Juror 96 felt a little uncomfortable.
Just kind of weird. I thought he was a little bit smaller than the pictures that I seen. He looked taller than what he was.
The picture that resonated with Lisa Christensen was Exhibit 17.
Of him with his hand in his pocket. That kind of got to me, like, this is my job, kind of don't tell me what to do, because he was in charge. That kind of bothered me a little bit.
As the trial progressed, Christensen was open-minded to the defense.
Mr. Nelson did a really good job. He was believable. He did bring out a lot of good points.
But she says prosecutors did a really good job presenting their case, and the evidence was on their side.
What was the key evidence in your opinion?
All the perspectives from the different videos.
There you
I think
go.
it would be harder to understand exactly what happened, but the videos is what really nailed it.
Particularly the video shot by Darnella Frazier and the teen's testimony
There
along
it
with
is.
it. Christensen was so close to the witness stand she could feel it.
It broke my heart when she said that she apologized to Mr. Floyd and she wished she could have did more to save her life. That's a lot for a 17-year-old to go through.
Do you think the use of force was reasonable?
I don't know. No.
Do you think that Derek Chauvin caused George Floyd's death?
I feel like the kneeling on the neck for someone did.
Christensen was convinced by the prosecution's top medical expert, Dr. Martin Tobin.
He actually had us demonstrate. We're touching our necks, the front of our necks, the back of our necks, as he was saying, and we could feel what he was trying to make us feel. So that was interesting. And then I guess what really did it was when he said, right here at this point is where he had that seizure, and this is where he died.
She knew the case was huge, but Christensen had no idea she would be so close during the trial to another death caused by police near her home in Brooklyn Center.
So when I came home, I could hear the helicopters flying over my house. If I stepped outside, I could see the smoke from those smoke grenades going on. I had a hard time getting to my house because all the protesters were blocking the intersections and stuff, so I had to go way around just to get home. So I was aware, but it did not affect me at all.
Christensen took the job seriously, taking notes every day. She did not know until the end.
All right, so we're going to get to
that she would
those
not
notes.
be able to help with.
We're going to get to those notes right now. Now, a couple quick things on that. So, again, it sounds like a very nice, honest woman, somebody who wanted to do her part in this whole thing. And, we applaud her for being a part of it. Not an easy thing to go through, no question about it. But that being said, right, we want to sort of critique her rationale, her basis for her opinion. Now, she didn't get to vote, but she said if she did, she would have voted guilty. But again, right, think about the basis for that. Very emotional, all emotion. Saw the video. Oh, the video was bad. Yeah, the one from the front, the same one that we all saw, right? That was the same evidence that she saw before she even stepped foot into court. I think it was her, right, who probably saw. I think everybody saw it or knew about it. And my point is, it was that did it. Then it was the multiple angles that just doubled down and confirmed what she had already seen. Then it was the emotion. She heard somebody testify. They lost him, didn't know what to do, right? Emotion, emotion, emotion. Then Dr. Tobin comes out and says, oh, it's right there. I mean, that's the moment right there. That's when he died. So she goes, oh, okay, well, Dr. Tobin was pretty convincing. That's it. I found him to be credible. So that's it, right? It's an expert witness, a video, and it's all it takes. It's not that complicated. Didn't hear much about causation. Didn't hear much about, the excessive force. But it was a short interview. But when you go through her notes, you're gonna see the same thing. It's not about causation, right? I was up here screaming about causation. I'm a defense attorney. I know that you can win cases on those issues. But I also recognize very clearly and obviously that most people don't think about those things the same way that I do. They don't care. They don't care what kind of guts are inside the computer. They just care that it turns on, turns off, and allows them to get on Facebook. That's it, right? I care about the nuts and bolts. And so when we're talking about the human operating system, I'm more inclined to say, well, how about logically and reason, okay, we've got all of these different variables that could have contributed to the death that look like they did, that were independently confirmed by expert witnesses that they would have, in fact, if they were the only variable, resulted in his death, and on and on. The list goes on and on and on. Right? So those things are important to me, whereas other people who are watching the same movie, the same stuff on TV, they're going, that goes one ear in one ear and right out the other. They're focused on the emotion. And so let's take a look at Lisa's notes. We can see them over here. We have Jenna Scurry, the 911 dispatcher, pretty impressed that she had a gut feeling something was wrong. She was brave enough to report it to the supervising sergeant. She turned out nothing. She could be wrong, right? Camera was freezing, use of force. So we've got, pretty impressed that she had a gut feeling. So a lot of emotion language. Donald Williams, he explained the blood chokehold. Thought I could see letters underneath his shirt. Wasn't sure if it was BLM. We have Daniela Fraser, says I filmed it. Broke my heart when she felt guilty and apologized to George Floyd for not being able to do more to save his life. I could feel her pain and her sorrow. What the hell does that have to do with what killed George Floyd? It was sad what we were seeing, but what about causation? Nothing to do with it, but it is very emotional. Says a 9-year-old, I could hear the sadness in her voice, right? And she's underlining this in red. I think this is her underlines. Alyssa or Kaylin, that was a 9-year-old. I could hear the sadness in her voice. 17-year-old, chin was quivering. It really bothered me. See that? Government is just emotionally beating the hell out of the jurors. Genevieve Hansen, firefighter, tried numerous times to help, strong witness, she wrote down. Christopher Martin, 19-year-old clerk, I could feel his guilt. Blaming himself for taking that. Can't believe it. He feels responsible. I'm mad at his employer for putting him in harm's way by asking him to go outside. Has nothing to do with George Floyd's cause of death. Nothing. It's against the law for an employee to pay back any fake bills, period. You need to train their employees better on how to recognize counterfeit money. This lady's not even talking about the case anymore. They have markers you can mark on the bill that will turn black if it's fake. What the hell is she talking about? She's talking about counterfeit money. They have a machine you can slide the bill through to see if it's fake. She's mad at the employers because she feels the emotions of this kid, Christopher Martin. And I remember his testimony. He's going, I was just going to pay for it, man, because I felt bad for the guy. She internalizes that so much she's trying to solve the problem. Just get one of those markers. Just get a bill, right? Stop this counterfeit crap. Again, nothing to do with the case. Nothing. Like nothing. What we're asking her to do now is not weigh in on any of that. It's about those legal elements that are in the jury instructions, specifically about cause of death. She's talking about counterfeit bills. Richard Zimmerman says something about being uncalled for. Dr. Bradford Langenfeld. We've got chief probate. There's an initial reasonableness in trying to get him under control, but once there were no longer any resistance, they got to let back up. Off of that, we got Dr. Martin Tobin. Okay, over here, she highlights most effective. Physical pulmonologist, critical care. So powerful. This is what made me certain that Derek Chauvin did was wrong and how dangerous it was. She wrote that down. He did a great job of explaining what happened so we could understand it. He had the entire jury participate. Very effective there if you're taking notes, if you're a lawyer. Right? Ask the jury to participate. I would have been curious to see if Nelson would have filed a motion in limine to stop that from happening. Final moments, the moment life goes out of him, he's conscious, seeing a slight flicker, then it's gone. So pinpointing that moment was effective. Let's take a look over here. Then we get over to the defense experts. We've got Barry Brode, use of force expert. This is the defense, says felt Chauvin's actions were justified and reasonable. Try to put yourself in the officer's shoes. Didn't believe the prone position was unreasonable. Then we have Dr. Fowler. Said George Floyd died of cardiac arrest and not from lack of oxygen. Said it was undetermined. Fentanyl, methamphetamines, exhaust, carbon monoxide, tumor, clogged arteries all contributed to his death. She wrote, not believable. Yeah, because it's not emotional. She really keyed in on some of that emotional stuff. And it worked. Got convictions. All 3 counts. So let's take a quick look at some questions over from watchingthewatchers.locals.com. First one comes over from Blaster Brain in the house. Says, what do you think about a concept like a judge overseeing the jury to make sure they're not ignoring the law in deliberations? Well, Blaster Brain, I don't really like. So the judge kind of does oversee them, right? They can't do certain things and leave, and so the judge has ultimate authority. But I think what you're asking about is, should the judge be going into deliberations and making sure they're following that? And the answer is really no, right? You want to keep that separate. The jurors free to deliberate how they deliberate. That's part of the system. There's a lot of reasons for that. You don't, because think about this, right? The judge is really the chief of the case. Judge walks in and says, oh, you guys are doing it wrong. You need to do it this way. Jurors go, oh, okay. So then is the jury really deliberating, or is the judge? Because the jurors are always going to defer to the judge, and you don't want that to happen. Patriot Musk in the house says, is 12 Angry Men 1997 version a good comparison to the Chauvin trial? Not sure if you've seen it. I have not seen it, but it seems if there is at least one impartial juror, then there can be a more genuine process to come to a verdict. I don't even know if that movie accurately represents what jurors go through. I haven't seen it, which is interesting, because I was alive in 1997. Don't know why I did not see that movie. I apologize for not being able to answer your question, but if there's at least one impartial juror, then there's a more genuine process to come to a verdict. That makes sense to me. If that is what the movie is portraying, I would hopefully, I ideally want every single juror to be impartial. But yeah, if you get one, for sure, that will make deliberations that much more effective. I'm not sure that we got that in the Chauvin trial, which is why it happened so quickly. Davis Parks says, how do we fix this problem? I always thought high-profile cases should have professional jurors. I'm starting to realize that judges with law degrees are just as partial as average jurors. Doesn't seem like a fair trial is even possible anymore for high-profile cases. I think that you actually might be right about that, Davis Parks. We're going to see. I think this is going to be a big problem for the foreseeable future. We're going to see what the courts do about it. And I think that, the more and more I'm starting to see some of this, the more and more I think that maybe Chauvin actually does have some teeth on an appeal, because this juror came out, we just heard from him, he sounded completely biased to me. Sounded like he wanted to get on the panel to effectuate an outcome. That is not what that's for. There are other mechanisms to effectuate that change. The court is not the proper venue for that, and the courts are not going to allow that to happen. Now, that being said, if the amount of pressure, the external pressure from society sort of overcomes the courts, they may not be, willing to push back on it. And we sort of saw that in the Chauvin case. We saw a judge didn't change venue, didn't even continue the case, didn't revoy deer anybody, probably had a massive amount of political pressure from city council, governor, mayor, everybody, maybe even the friggin' president for all we know, who knows. But the point is, if you have that pressure come down to bear, and the judge is the last protection, the court is the last protection of due process, and the courts are buckling under the weight of public pressure, that is not good. And, I don't know what the courts are going to do to solve some of this, but, ultimately down the line, we're going to see here in the last segment that the judge out of North Carolina is actually not releasing information about the case, right? So that could go the other way. We could just say, well, you don't get any information then about it, because the public is going to interfere and wreck the justice system. They're going to wreck the justice process. Nobody's going to be able to get a fair and impartial trial anymore. So we got to lock everything back down, which I don't like that answer a bit, because locked down information, no transparency and no accountability just breeds corruption. And we all know we already have enough of that. We have Justice First in the house says, think they need to be able to go through more potential jurors, lots of them, and allow the judge to dismiss them off the top. Many of the jurors that were selected, I thought, seemed unfit by their initial responses, but instead of dismissing judge was trying to reform them. Yeah, and that's I think that's a very fair observation. Justice first, and this is very common. Judges do this often, right? They sort of are defaulting to putting people on the jury panel. They do not want to let you squirrely your way out of it. So if there's any way to sort of keep you in there, they're going to try to do that. We have See the Veil says, I heard the judge say that there was no transcript or record for the jury to review. The jury had to remember and have good notes. How is this normal or legal to do? I don't understand this being the norm of jury process. Well, See the Veil, it is in fact normal. This is how it goes, because here's what happens in a trial. If you needed to prepare a transcript, both sides would disagree about the transcript. This is what happens in these situations. A witness would testify. Let's say hypothetically, we want to have certified transcripts of every single statement that was uttered in this trial. It'd probably take, a month to generate that. You'd have to, yes, you have a court reporter who is typing everything. That's fine. You could easily give that to the jurors, but you would have both sides objecting to that. You'd have the defense saying, that's not what they said. Nope, that's not how that happened. I object to that statement. You wrote that wrong. That was out of place, whatever. They would object over every sentence. Government would do the same. And you'd have to go through these multiple rounds before they could even agree on a transcript to get back in front of a jury. So the jury, look, you get one shot at this thing. Listen to it. If you want to listen to it, then that's it. You get one crack at this. We're not going to draft a bunch of transcripts and allow you to go back and scrub through every sentence. Listen, give us your verdict. So some of that is practicality, right? Some of that I think is probably antiquated from our old era where we just didn't have the ability to come up with transcripts and to video record things and scrub through video files. But there is also some really good, human nature reasons to do that. You pay attention. You're not going to get to go back and look at this stuff again. We want you to be engaged and involved in the trial. And I think there's a lot of good argument for keeping it the way that it is. But I understand your point. LT13 says, this is the second juror to say Tobin made the difference in the case. Those are the slides given to the defense the night before. Could this be important in his appeal? It could be. I think he objected to that at the time and objected to it right after Tobin's testimony, basically saying it could have been him. Don't quote me on that one. A lot of witnesses. I'm not sure if it was in fact Tobin, but there was some conversation about slides not matching. In other words, the prosecution delivered the slides to the defense, but then when they presented their evidence in court, they didn't match because they updated a couple things the night before. And if something like that happened, theoretically, it could be something that the appeal that would make its way into an appeal, but whether it would reverse the outcome in the case is a separate issue. So I'm not sure how substantial or significant it would be. Obviously, if it was Tobin's testimony, yeah, it was pretty significant because two jurors now are confirming how impactful that testimony was. It's Ed says, how do we get rid of systemic racism if race is always brought to the forefront of every discussion? Deep question, I know. Sorry, Rob. Hi, Miss Faith. Hi, Ma. What's up? It's Ed. So how do we get rid of systemic racism? I don't really know the answer to this. I would love an explanation to it. I've poked around. I've tried to see what BLM wants to do about it. I have no idea what they want to do about it. I've poked around in some Clubhouse rooms. Clubhouse rooms have been fun. There are a lot of these rooms that are dedicated to this topic, and I poked around in one. And they were talking about reparations. In fact, they want reparations, I think, to the tune of something like $4 quadrillion, I think was the last one that I heard. And so, I don't know if these are serious proposals or not, but I don't really know what to do about it. If there's a reasonable solution here that we as a society can come to solve this problem, I'm open to it. I'm open to hearing what the solution is. I'm not so sure that I agree with the premise that there is this systemic racism. I mean, I know that there is sort of racism in, I would say, little silos across the country. And I know that they are sort of intertwined with systems, but I don't really know what that means. I don't even know what does systemic racism mean? Is it everywhere? Is it on everything that we do? I mean, if I wake up in the morning, am I inherently racist? I think that's what they're saying, and I just don't agree with that. So if that is their premise, that we all are sort of just born, as long as you're a white person, right? I'm Italian, so I think I qualify in that category of a Caucasian person. So I think I'm just automatically racist. So I don't know how I wean that out of my system. I don't know if there's a pill to take or if there's a lotion or a cream or something, that you someplace you go and somebody zaps you. I don't know, but I'm open to it. If there's a solution, I'm open to it. It's Ed says, didn't Biden continuously say that he wanted the opportunity to make amends for his crime bills? Has he done anything yet to scoot Congress in that direction? So not really. Currently right now, it's just a lot of talk. It's a lot of bloviating, a lot of, George Floyd bill and this and that and the other. But, it's his first 100 days. We'll see if anything comes down the pike later down the road. But I don't think so. I don't think that we're going to see much on this because it's just been a lot of talk. Remember Joe Biden, 1994, 1988, 1986, 1984, all crime bills, and he's been somebody who's been very proud of that, said that anything that came out of the Senate that touched on crime since 1976 had Joe Biden's name on it. All right. So we've got his record there. We've also got Kamala Harris. Joe Biden didn't do anything when he was vice president for 8 years. So why is he going to do anything now? Him and Obama could have done something to fix this for 8 years when they were in office not that long ago. They didn't. So, they want to blame all of this stuff on, I guess, racist Republicans. Joe Biden wrote the crime bills. He's the godfather of our criminal justice system more than anybody else that I can think of. I don't even think there's anybody who even shines a candle to him in terms of creating the environment in which we live. So if people, really want reform, the man who created the system is in charge right now. There is nobody better to unring that bell. We'll see if he does it. And Kamala Harris, too, same story, right? AG, Attorney General, prosecutor out of California, laughing at people, making fun of them for wanting more water. Oh, please, sir, more water. Remember when she did that? She's the vice president now. Some say the president. Let's see if she can get out there and actually improve society for people. Or is this just a grift? It's been a grift ever since I've been practicing law. A lot of people want to just rant and rave about our broken justice system so that they can generate funds and then go on talk shows and rant and rave about it. But the problem is people are sitting in custody. People are being killed in our system right now. And this is a direct result of us. This is our government. This is not some bizarre, strange thing that we can't control, right? This isn't the coronavirus that nobody knows what the hell what it is, where it came from, what it does, how it works, or any of that stuff that we just can't wrap our hands around. This is different. This is our system. This is our justice system. We can just write a new law, pass a new bill. We can release a bunch of people who don't need to be in custody because they're nonviolent offenders. We can help more people who've been incarcerated because of drugs. There's a lot that we can do. Nobody wants to do it. Ask yourself why not. Ask yourself why the people who created the system, who are now in power and have been in power, let's say 2 of the last 3 presidential terms, they were in charge. Why is nothing getting changed or nothing getting fixed? They have all 3. They have the House of Representatives, the Congress, the Senate, and the White House. Where's the bill? Where's the bill? We're going to hear from Biden about 1.3 trillion or whatever it is, in addition to whatever the last 2 or 4 trillion were. See if he crams justice in there. Doubt it. Patriot Musk says, Rob, do you believe the jurors took this trial seriously and looked at the evidence diligently? No, I do not. I think they did take it seriously, but no, I don't think they really looked at much evidence. She just said that Chauvin had his hand in his pocket. Yeah, and I think that one kind of caught me too. I think I've mentioned that, and it really wasn't, right? He was wearing a black glove, so it looks like it's in his pocket, but it wasn't. But that juror said that it was. It's Ed says, last question, I promise. Do you think the jurors understand the concept of reasonable doubt? No, I do not. It's a tough concept. And it's one that defense attorneys spend a lot of time just hammering because it's difficult to grasp. And most people think that if you're in court, you did something wrong, right? The presumption of innocence is sort of non-existent. And the idea that the government has to prove it beyond a reasonable doubt, that if you have any doubt about whether a person committed a crime, any doubt, and as long as it's reasonable, if you have 1% doubt and it's a reasonable doubt, that's a not guilty verdict. But people don't understand that. They go, oh, that's more likely. I think, Dr. Tobin said that that's when it happened, so I believe him. Okay. What about all of the other expert witnesses from the government themselves who say that didn't happen? Dr. Baker said that. The government's witness. Tobin came out, pulmonary asphyxia, low oxygen. Dr. Tobin said that. Dr. Baker comes out, no, it wasn't. Heart failed. 2 witnesses on the government side, both work for the government, disagreement about cause of death. That's not reasonable doubt? I don't know what is. Sharon Quidney says, here we see the total politicization of the judicial and legal process. We have political prisoners, Capitol Hill, seizure of Giuliani's electronics, overriding attorney-client privilege, Ida pogrom, a purge. Yeah. Yeah, it's weaponized. Everything is getting weaponized, including the justice system. It's a big problem. Sharon Quidney says, the second problem is that for many years, the emphasis in the culture and in education to focus on feelings rather than intellect and reason. Most folks have been taught not to engage in critical thinking. That's exactly right. And this last 12 months has really shown that, hasn't it? We've seen this. We've seen that anything the government says, people just lap it up, just like good little sheep. Oh, yeah, okay. Oh, Dr. Fauci, okay, great. Whatever you say, I'm going to do, even when the government lies to you, literally. I mean, they've been lying for the last 12 months about a number of things, and they regularly do. We don't need to get into that here. Otherwise, lest we anger some of the tech lords. But it is a problem. People just say, well, I saw it on CNN. I'm just going to accept it. Okay. If you want to live your life that way, I guess that's fine. But I don't. Neither do you, which is why we're here talking together. Farmer's daughter says, Rob, do you think if the jury had some questions for the lawyers and judges during deliberations, they would have had more reasonable doubt or nothing would have changed? So I think you're asking if the jurors would have come forward and asked some questions. Typically, that is sort of indication of reasonable doubt. They're asking questions. They've got some things that they're thinking about. That's good. We want them to think. We don't want them to come through and just across the board have a unanimous guilty verdict. And so from a defense attorney perspective, when they're asking questions, that's a good thing, because the worst thing that can happen is they don't ask any questions. They come back out in 8 hours. They deliver across the board convictions. We have Farmer's daughter says, I've noticed the family make sure they are out front immediately after a shooting now. Do you think it's because the dollar signs after the Floyd trial? Seems like a dangerous precedent. Yes, I do. And I made this same comment on the Ma'Khia Bryant shooting, right? I saw this. We had the aunt who was out there acting performatively in front of the cameras. She wasn't even there when the shooting happened. She showed up after the fact to start doing this screaming, wailing thing in front of the cameras. I lost my niece. Why? So that she can be a part of the settlement. I think it's 100% to collect money. No question in my mind that she's grieving and mourning the loss of her niece, who apparently was in foster care already. And, mom wasn't particularly broken up about it either, because she was on camera that night. There was still caution tape surrounding the neighborhood, and she was already out speaking to the cameras. Something felt off about that whole thing. But yes, if you're going to get a $27 million settlement, why wouldn't that make your ears stand up and you want to be a part of that? We have William Lowe's has the juror saying Chauvin failing to testify hurt him not been brought up. So I saw that. I did not clip it here on this channel, but yes, this was a part of the interview. The juror said it was probably to his detriment that he didn't take the stand, because people were curious on what his thoughts were throughout the entire incident, which was a point that I made, right? And I still think it was probably the right move not to put him up there. I think that this jury would have convicted him regardless, as we saw. I don't think anything he would have said would have changed anything about it, and it probably would have just sealed his fate, because we're also hearing that they just didn't like him. They didn't like how he was looking. And I also commented about this. I said, I go back in the archives when the judge was asking him, when he was waiving his right about testifying, the judge said, well, did anybody force you or threaten you, to not testify? And Chauvin kind of went like, no, judge. Nobody puts me under duress. Okay, I got this. Sort of had that little face and that little smirk. And I sort of freeze framed that puppy, because I noticed it very clearly. That's not a good attitude, brother. If that comes across to the jurors that you're just kind of thinking like you got this thing in the bag, people can just sense that, even from across the room. And we've heard some jurors say that. Osak71 says, Rob, big fan. So should have the defense just stuck to simple theme with the trial? Sounds like too much info killed the defense. So I think that it was probably not enough info, if I'm looking at it now in hindsight, because or let's just say that the experts that they presented were not as compelling. They needed a response to Dr. Tobin. They didn't have one, which I think is really what did it. Joe Snow in the house says, seems pretty simple, like Morgan Freeman said not too long ago before he started shilling for experimental gene therapies. We just stopped talking about it. Morgan Freeman. The voice from heaven. Liberty or Death says, systemic racism is a myth. We are to believe that the system is so racist that Kamala Obama was elected, LeBron James became a billionaire playing basketball, want to make liberals' head explode. Ask them if the descendants of blacks that owned slaves should pay reparations to descendants of slaves. Oh, yeah, that's a good one. So, yeah, if you're a black person that owns slaves, are you also a part of the problem? Sounds like a white supremacist to me. All right, we've got Quayne in the house. Says, Rob, does it look like the jury member was reading from a teleprompter? Ooh, I didn't catch that. Looking left, while quick, short eye movements back and forth. I don't know. Looks a lot like a script. Oh, interesting. I did not catch that. But I do like to watch people to see if they're reading. You can see that with Joe Biden. And you watch him as he's like, watch my eyes. As he's reading, you'll watch his eyes go up and follow the text. I don't have a teleprompter on here, but his eyes will go up and you'll see that he kind of loses it. And then the person who's running the teleprompter stops it. And then his eyes come back down. He catches the next line. And that little bit of panic that you see as his eyelids just kind of opening. I'm not a body language expert, but I love to watch this stuff. And I've watched a lot of people in, clients, courts, judges, prosecutor, everybody. And you can kind of see it. He gets a little bit panicky. Then the thing stops. He catches back up. Sometimes he'll make a little bit of a remark out there. He'll go, oh shucks, whatever. I'm an old man. All right. Then he catches back up, continues on with the reading. It's pretty obvious once you see it, in my humble opinion. Joe Snow says, when Nelson started his cross about, isn't it reasonable if there was a gun battle occurring, I literally lost what little patience I was able to muster to hear him out. Cop-splaining is for cops, not trial lawyers, in my humble opinion. Yeah, I think it's a good opinion. Yeah, Nelson is not without criticism here, right? Nelson, I think he did an excellent job. I'm not a person to try to belittle another attorney's performance unless it's something that's grossly incompetent or anything like that. But Nelson, I thought, did a very nice job. I mean, he was in one of the most difficult trials, I think, that any defense lawyer could find themselves in, and he held it together. He did a good job. Larry Light says, Rob, can you compare this to the clear and convincing evidence standard? So beyond a reason, I can. I don't have my chart in here today. I will bring my chart in here another day, Larry. I have a chart that walks through all the different tiers, but it's a lower standard. So clear and convincing is sort of the middle tier standard. You have preponderance of the evidence, which is sort of like 51% likely. We say beyond a reasonable doubt is like 80% if you want to use percentages. And then clear and convincing is sort of in between the two of those. And so you can sort of flesh that out however you want. But it's a lower standard than the criminal standard. And in criminal law, it's beyond a reasonable doubt, which is the very highest standard that we have. So that will be for I think that's for like child custody and those types of cases. But I don't do that type of law. Doodle Doo says, why were the private notes of the juror made public? Well, she gave them to the news media. So that's why they're out there. Was she paid to release them? I don't know. It looked like a total virtue signal to me, probably. Like she knew that riots were happening close to her home and wanted to make it obvious in public that she was on the side of George Floyd so the rioters wouldn't come after her. Well, maybe. Yeah, it could have easily been that, right? It could have been that situation. I don't know. But it is interesting, right? She kind of approached the media, said, here are all my notes. Take a look at everything. Curious. Beverage break. All right. So great questions. Those all came over from watchingthewatchers.locals.com. Thank you so much for your support and your love over there.